Let's go to the next question. This one is about detention. I like that. Okay. What is that? My father was detained by ICE after missing an immigration court hearing years ago. Can we reopen the case and stop removal? That's an interesting one. Kevin, Sacramento. Yes, it may be possible, but you have to move quickly. If your father missed an immigration court hearing years ago, the judge may have issued an in absentia removal order, meaning a deportation order was entered because he was not present. So you first have to check the immigration court to even see whether a removal order has been entered against him. Now, let me even see if I can give you that number on here. There's a number you can call to check whether you have been deported in absentia for not showing up. I don't know it often. Let me check my Rolodex here. And you may want to call that number if you don't know that number already. Immigration hotline is what it's called. Immigration court hotline is 1-800-898-7180. 1-800-898-7180. You want to call that number first, just to be sure what happened when your father missed an immigration hearing. But apparently, he was even detained. From what you are saying here, immigration already even got him after a missed court. So that means they probably already entered a removal order for him. But double check that. Now, to reopen the case, we need to know why he missed court. Because you have to have a strong reason why you miss court before you can even begin to apply for them to reopen your case. Strong reasons probably might include that he never received the proper notice of the hearing. If he never got the notice, then that's a very good reason to reopen the case. If the notice was sent to the wrong address, if he was detained, hospitalized, or had an emergency on that day, that's why he could not show up. Or if he had what I call ineffective assistance of counsel from a prior lawyer, maybe his lawyer did not inform him that he has a court date, or his lawyer misinformed him about what will happen on court date. So if he has one of those 4 reasons, he actually can get his case reopened by a competent immigration lawyer. In other words, I'm going to repeat those 4 conditions. If he can meet one of these, then he has a good chance of getting his case reopened with the judge. Number 1, if he never received a proper hearing notice, because they're supposed to serve him about the court date. Number 2, if immigration sent his court notice to the wrong address. Number 3, if he was detained, if he had an emergency or hospitalized on that day, that he's supposed to go into court and he can prove it. He may have a good case to reopen. If his lawyer was ineffective, and there are many ways a lawyer can be ineffective, maybe gave him the wrong advice about going to court, or maybe the lawyer did not inform him properly about the court date, and then he can reopen his case based on ineffective assistance of a prior attorney. If there was no proper notice, a motion to reopen may be filed even years later. A lot of people think that you have to do it within 30 days. No. If there was no proper notice, like I've explained, let's say he never received hearing or he was sent to the wrong address, then he can reopen his case even if it's after 10 years. So you can get a lawyer and they can work with you in reopening the case. If the reason was an emergency or exceptional circumstances, then deadlines may be stricter. Okay, when did the emergency end? How long were you hospitalized? How come you are released from hospital more than a year ago, but you didn't reopen, that kind of thing? But because it's now detained by ICE, your lawyer, or go get a lawyer who should immediately, 1, get his immigration court records, check whether he has a final removal order, file a motion to reopen if legally available to them, request a stay of removal, or evaluate bond or release options. So those are 5 things a new lawyer could do for you. First, he has to get the immigration court processes, records. check whether he has a final removal order. Then he can probably file a motion to reopen if it's legally available to him based on the conditions I mentioned before. He can request a stay of removal if there are conditions for that. And then he can also evaluate what are the bond or release options that he can pursue. So the key point is this, Kevin. Do not assume deportation is automatic because immigration got your dad or whatever. If the mishearing can be legally explained, especially due to lack of notice, the case may be reopened and the removal may be stopped. So don't lose hope. You just need to start taking action, massive action right now. Look for a competent attorney that can step into the case before they take him out of the country. Delay is dangerous. Immigration don't play now. They will put him on that bus. They will put him on that plane unless you start getting some serious papers filed by a serious lawyer.